Court does call the case of Akash Pravet versus James Mack. Okay, not the way to start out this block.
Good afternoon, Your Honor.
Oh, they're on Zoom.
Well, thank you for allowing me to appear by Zoom today, Your Honor.
All right.
Your Honor, in this
All
matter,
right, where are we on this case?
well, I don't know that we're any further than we were last week. I know we had a rent balance of $10,852.85 with $162 in cost for a total of $11,014.85. I think Mr. Mack was seeking whatever assistance he could find, and that's why we're over to today.
Yes. And did you receive an answer from your state emergency relief application, sir?
I have not. They have to schedule an appointment. I submitted the paperwork on Wednesday that we applied for it. I'm just waiting on an email to schedule an appointment to speak with them.
Okay, so they haven't made a decision.
No, they haven't given us anything. I submitted the paperwork earlier this
All
week.
right, then he's entitled to another adjournment for that purpose. I don't, of course, have next week, so this matter will be adjourned December 5th, 2025 at 3 p.m.
Okay.
And would I still be able to appear by Zoom on that day, Your Honor?
I don't grant my permission that way. You're going to have to fill out the form. I tell you that every time. Thank you.
Thank you.
Thank you.
Court calls the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff.
Come forward. Afternoon. Your name?
Hannah Schumacher.
All right. And where are we on this case?
Your Honor, I think we have the matter resolved. I've had some conversations with the city that are kind of inconclusive, and my client's been working with them. But in the meantime, if you recall, this is the case involving the problem with the trash can and the city citing us for it.
Oh, how could I forget? Yes, I do recall.
Yeah, some stick better than others.
They did that. This one stuck because I didn't understand.
Well, me neither. So where we're at, I talked to Ms. Schumacher this morning, and my client has provided a trash can, but it's not it hasn't been lockable. So I think other people have been filling it. We've been emptying it twice a week. So we provided her with a written assurance that we're going to empty it twice a week. We're going to put a lock on it by Monday, so that the neighbors will stop using it. And my understanding is that's acceptable to Ms. Schumacher. And if it is, what we would do is enter a dismissal that would also provide that the escrowed money would be released to the plaintiff.
Your Honor, I'm okay with that. I will release the escrow funds on Monday once the lock, and
Okay, you have the escrow funds because we don't, right?
Yes.
Okay, so you're gonna pay them once the lock's put on and people start putting this, and you don't have to drive it to where? Dearborn, was it?
I mean, the border, basically, Toledo, Ohio.
Pardon?
Ottawa Lake, Michigan.
Oh, you're driving trash all the way out there? Wow.
Your Honor, her parents are going to be very disappointed with us. I'm sure they were happy with us.
You know, it's true.
Having had kids in college.
Probably happy because they got to see their daughter.
Exactly.
But, I mean, now she won't be going out there, and you know, we probably should get something from Mom asking if she wants us to just keep it the way it is. Her daughter comes to see her. I mean, I don't know anything about your family, but I'm just saying that's the way parents are. All right. What I'll do is I'll adjourn this out to December 5th, 2025 at 3 p.m. with the hopes that then there'll be a dismissal and you won't need to appear.
Okay.
All right. Fantastic. Have a happy holiday.
Thank you.
Thank you, Your Honor. You have a good weekend, though.
You do the same, sir.
Thanks.
Court does call the case of David Pata versus Seth Barton.
Good afternoon, Your Honor. Paul Fester on behalf of Dave Pata.
Your name, sir?
Seth Barton.
All right. Where are we on this?
If you recall, 2 weeks ago, Your Honor, you allowed my clients to get a storage pod to move the property out of the house. He ended up not having to do that. defendant actually moved a lot of his possessions out of the garage right away, which allowed my client to take the items from inside the house and put them into the garage. So we did not have to go through the storage pod procedure. Defendant has got a lot of his possessions off the property at this point. The garage is mostly gone. The vehicles are mostly gone. The property inside the house doesn't appear to have been touched very much, and the livestock is still there as well, which my clients have been taking care of for the last couple of weeks. So that's where we stand. We're asking for a judgment of eviction and have him get the rest of his property out within 10 days.
Sure.
I'm still moving the rest of the stuff out. It's quite a bit of material, as was described. I think one thing that's been overlooked through this case was that I've actually known Dave for almost 20 years. He knew what I was bringing to the house when I moved in there. This was not a surprise to him, even including the livestock animals, which, as a fact, they're currently, I'm working with a sanctuary to take possession of them. I hope to have them removed this week. And I was planning on bringing a dumpster to remove all the material that was destroyed during the flooding of the basement from the pipes breaking. If that's still acceptable with Your Honor and Mr. Petta, that was still part of my plan, was to clean up all the damaged material that the insurance made us hold on to until the claim was resolved. As far as the destroyed material, I'm still accumulating a list of value of what was there that was destroyed that my insurance is not covered. And I did plan on presenting a motion to try to have that rectified as well to get this brought to closure.
So when you say bring a motion, I'm not sure what you mean by that.
During my initial response to their asking to have me evicted, I stated in there that there was $40,000+ worth of material that was damaged during the flooding and the breaking of the pipe. My insurance company only covered $20,000 of it. It was their direction that I should try to sue Mr. Petta and his insurance company to get the remainder of the amount of lost material.
So why hasn't that counterclaim been filed as of yet?
Because I have not finished inventorying all the damaged material from the house as I've been moving it out here. I could put it in right now, but it would be a partial value. It wouldn't be the total amount of what's been destroyed.
Well, but you at some point have to put plaintiff on notice of the claim. And okay.
Your Honor, there's nothing preventing him from filing. I mean, this is because it's landlord-tenant law. We're in a unique area here. He doesn't have to bring it up.
Well, he actually, go ahead.
Well, my client is probably going to be bringing a complaint after all the calculation of the damages caused by defendant's use of the premises. There's been no counter complaint filed. This has been in front of the court 3 times. This is the first we've heard of it. If he wants to bring a separate action, he's free to do so. But I would just ask that we enter the order of eviction today.
Well, I don't think I'm going to do that. When are you going to have your counterclaim? Let's just get this done. I mean,
I plan to have the rest of my stuff moved out and inventoried with the end of the holiday here, Your Honor. I'll have some extra time off of work. I already have trailers lined up rented to get the remainder of the material. I've rented a storage unit to where I can place the molded material so that it's not contaminating.
So, sir, you know what? You give me these reasons and everything. I mean, it seems to me that until you're pushed to the edge of having to do something, you don't do it. Because the moment, I mean, we were here before and you were giving me every reason in the world why it couldn't be done. And then the moment I said that there's going to be a pod put out there, all of a sudden, the next thing you know, you can empty a garage. So I think you can get this stuff out of there. You can do that and you can do it in, I think, rather short order. I don't think it's what you're claiming it to be to get that property out so that the property can be repaired and looked at. I mean,
I also didn't acquire a new place to live until Halloween was when I closed on a new house. So prior to that, I was living out of a hotel with my son.
Okay, I wasn't asking for an excuse. I'm just telling you what my observations are. So when is the rest of this stuff that you want going to be out of the premises?
By Thanksgiving, is that acceptable? 1 week from today.
Sure, I'm going to order. If the defendant is going to file a counterclaim, he's to file that counterclaim no later than December 1st, 2025. I'm also going to order that the defendant shall remove all property from the premises which he desires to claim. He's to do that by November 28th, 2025. Any property left on the premises as of 12:01 a.m. on December 1st, 2025, this court will indicate shall be deemed abandoned and may be disposed of by the plaintiff. All right. I think that will solve that. I will then adjourn this proceeding so that I realize it wouldn't permit time for an answer, but I'm going to set this for December 5th, 2025. What time?
3 p.m.
At 3 p.m. And I'm doing that. If he doesn't file, certainly, counsel, I would entertain your request for relief.
Thank you.
All right. Thank you, folks. Group 5 management versus Turbington. That matters just on plaintiff's motion without prejudice.
Thank you, Your Honor.
Oh, okay. Thank you, Mr. Weiss. We have your dismissal, sir.
Thank you. And I put
All
money
right.
on Maryland this weekend.
What'd you say?
I put money on Maryland this weekend against Michigan.
Okay, so I say this as a terrapin. You just want to lose your money, do you?
No, I got points.
Well, we'll see.
I got points. Thank you, Your Honor.
I always believe in miracles, but we'll see. All righty. Thank you, sir.
Have a nice holiday.
You do the same, my friend.
Good afternoon, Your Honor. J. Latif Beg, BAIG, P36820 on behalf of plaintiff.
James Mack walked into court owing more than $11,000 in rent and claiming he had just submitted his SER paperwork. But when the judge asked for proof, things got tense. With no decision from the assistance program, the judge had to choose eviction now or one final extension. What happened next left the courtroom silent.
Your name?
Chef Thompson.
All right, where are we on this case?
I think it's his motion to set aside a default, I believe.
Yes, it is. Sir?
Say.
Come up here.
Oh, sorry.
You filed a motion to set aside the default?
Yes.
Okay. Why should I set aside the default?
I was in a psychiatric hospital.
Pardon?
I was in the hospital. In a psychiatric hospital.
Okay. And to set aside the default, there has to be two parts to it. One would be that for good cause for your failure to appear, which that may be, but also that you have a meritorious defense to the claims.
Don't know what that means.
Okay. Well, what are your defenses? It's a termination. My understanding, if I got the right case, was that the lease expired or what was?
You're on lease violations.
Yes, the lease violations. What were your defenses to the violations, claimed lease violations in this case?
I don't really know what they were. I know that they presented them, but
Pardon?
I don't really know what they were. I wasn't, like I said, I was in the hospital at the time, but I couldn't show up. But there were a number of psychiatric concerns that I had that weren't addressed until recently, and that I'm still continuing to go through treatment on. And I just completed a program yesterday that was a partial hospitalization program, and then
Sir,
I don't know.
hold on a moment.
Okay, sorry.
On October 17th, the first hearing on this matter was held. You were present.
Yep.
Right?
Yeah.
You came back, and that was before Judge Barr, but you came back before me on October 24th. I set the matter for final settlement conference for November 4th, 2025, and had ordered you to file a written complaint by October 31st.
Oh, I was in the hospital then. I called the court too, and I spoke with the court clerk and let her know that I wasn't available. I didn't know what I needed to do in order to make sure that was taken care of, and said that they were going to notify you, but I just got out of the hospital, so I don't really know what's going on. I haven't had a chance really at all to talk to Alex.
What day did you go
Alex
to
Henry.
the hospital?
I'm sorry?
What day did you go in?
The 29th, I think. Was it the 29th? Or was it?
And what day did you get out?
It was about a week and a half, 2 weeks later.
Well, you got out the 5th, right?
I don't know. I might have, yeah.
Pardon?
I might have, yeah. I don't recall what the actual date was. I'm sorry.
So before that point in time, sir, you knew what the violations were.
I think so, because I was working with Alex Henry on it from Legal Services was helping me. So yeah, they had sent a packet to the house. Well, engineer had sent one, brought one up too. It was a hard copy of the.
Who are you looking at back there?
Oh, I'm sorry.
What? Pardon?
I work in the leasing office for Henry O. Clark.
Sorry, I don't mean to look back at her. I just.
No, well, I didn't know if you had somebody with you or.
Oh, no, I get nervous when I'm in here. So I'm, especially in front of you, I'm like, I don't know. I don't understand exactly what's going on. I just trying to do the right thing. So
where are you residing right now, sir?
I just got back out of the partial program yesterday. So I went back to my apartment yesterday. Alex Henry said he talked to somebody from the court. I don't know if it was.
Pardon?
Alex Henry. He said that he talked to somebody from the court, Legal Services did. I don't.
Talk to somebody from the court?
Yeah, I thought it was you. He said it was.
For me?
Off the record.
No. What? But about what?
I don't know. I don't know.
He had been hospitalized, but
that was it.
Yeah, they said they couldn't because they didn't have the resources.
Sir, so are you indicating the reason you couldn't comply with the court's order to provide a written answer to the complaint is because of the hospitalization?
I was in the hospital. I wasn't able to physically get out of the hospital and bring it up to you.
Right, except that, just follow me here. I told you that on the 24th. So you have it now?
No, I didn't even know why I was coming here today. I said, Alex said that I had the appointment at 3:00, that I'd show up.
Who told you?
Alex Henry, the attorney at Legal Services, said it was scheduled for today at 3:00. I'm sorry. I thought.
All right. So it's not really a motion to set it aside because I actually set aside the judgment based upon what was sent, but I'm not seeing a defense to the claims.
Oh, so that's what the write-up's needed for then.
Okay. All right. Let me do it this way.
I'm sorry. I don't want to.
No, it's okay.
I don't want to lose my place either.
I know, I understand that, but plaintiff wants, they want possession of it, and I've got to get this case in a position to rule up one way or another. So how long will it take you to get an answer to me?
I can do it today or tomorrow if you want. Get it in on Monday. I just don't understand I'll call Alex. I'll call Alex.
Pardon?
I'll call Alex and ask. I don't understand what I need to do though. Like, I need to tell you what happened.
You need to file a written answer. Okay. Now, if you need help with an attorney, you need to talk to Mr. Henry or somebody at Legal Services.
Okay.
All right, but I'm not.
Well, then I might have to give it a couple days to get a hold of him then. I'm sorry. I don't need to.
Here's what I'm going to do, Councilman. I realize this delays the.
Your Honor,
go ahead.
The way I'm seeing this case on the ROA, the status is disposed. I was unaware that you would have set aside
on the 10th. Because of what I had received, I issued the judgment on the 4th. I then received the medical documentation November 10th as to why he did not appear. And at that point, considered it sufficient because I didn't get an answer. I didn't get anything. And also it cut into the period in time at which he was to provide an answer to the court. So
I'm sorry.
If he was going to provide an answer, say on Halloween, which was the deadline date, he wouldn't have been able to do it because he was hospitalized. I don't have the timing of that, but it basically cut that period of time in half. And so I did, and I noted on the ROA that the judgment is set aside, and I set it for a hearing for today. But in setting it, he's been out of the hospital, which is really my point, from the 5th. From the 5th of November to today, I still don't have an answer. And that's part of my problem. But he's telling me he didn't, I don't know what entirely he's telling me. But you didn't prepare an answer at all?
I started to, and that's what I was supposed to meet with Alex on, but I didn't have a chance to meet with Alex because Alex isn't representing me. He said,
Your Honor, I understand that he was in the hospital, and sorry that that happened, but he knew that he was supposed to file an answer. The answer was to give us plaintiff some sense of what defenses he may be raising. That's why he set the settlement conference. Now it's been since he's been released from the hospital. I take it the 5th to today's date, which is the 21st. We're looking at 16 more days. My client wants possession of their property. It's just been delayed too long. But I leave it up to you, Your Honor.
I haven't hurt anybody. I never intentionally like that.
Sir, I need your written response to the plaintiff's claims.
Okay.
So you're telling me a couple of things because you said you couldn't get it to me, and then you said you started it
the day that you told me to ask for it. That's when I called.
Pardon?
The day that you told me to start it.
All right. Here's the way I'm going to do this. I'll give you some additional time. I'm not going to give you as much time because you said you started it.
Yeah, I mean, I don't, unless I think I should talk.
Unless what?
I don't know if I should talk to Alex or not. That's.
You have on the complaint council of records number and can get that to them. I think there may be an email address. You need to send, pardon?
I've got a cell phone number.
Okay. You need to send a copy of your answer to the plaintiff's attorney. You understand that?
Yep.
And you need to file an answer with the court.
So it's both.
Yes, both. You need,
All right.
need to file and send them a copy so they know what you've given to the court. But I'm going to put you, since you said you already started it, I don't think we need a lot of time. So you need to do that by this upcoming Wednesday, the 26th.
Okay. Thank you.
He said he submitted the SER application on Wednesday. He said he was still waiting for an appointment. And with over $11,000 past due, his landlord wanted answers. Watch what the judge decides when James Mack reveals he still has no confirmation, and the tension reaches its peak in court.
And then I'm going to get back to the final settlement conference portion of it, counsel. So from a client's perspective, I'm going to set this for final settlement conference hearing December 2.
Yes.
December 2nd, 2025. That's at 9 a.m. That's an in-person proceeding. So you need to be here at the court. They need to be here at the court. And we'll see if we can resolve this thing short of trial. If not, so that you understand, I'm going to be setting the matter for trial rather quickly.
Okay.
Understood?
Thank you.
Whether you have Mr. Henry's advice or not.
I understand.
That's the way I'm going.
I just thought I was doing the right thing. I didn't know. So.
All right. Thank you, counsel.